Hello everyone. I'm here today to talk to you about a legal development and how it impacts you and your use of AI. If you have ever used AI to do any kind of research, and in particular legal research, that information you plug into the system is going to be admissible. This all stems from the case the United States v. Heppner. Mr. Heppner was charged with various crimes, including wire fraud and other funds coming from the company that he was running. Before he was charged with the crimes and knowing that the investigation was happening, he used Claude to do his own individual research into the crimes that are being alleged and what defenses he could use. As a result, he plugged in information that was very specific and very private, or so he thought, in order to develop a defense and to prepare himself when meeting with attorneys. Eventually, he was arrested, charged with the crimes, and the FBI seized his property, including the devices he used to do that legal research on AI. As the case developed, the government wanted to use the information that they were able to obtain from downloading it from AI, but his attorney argued that it was confidential or work product. Now, confidentiality is established between an attorney and a client, even if it's just for a consultation. Confidentiality is established between a potential client or a client and with an attorney. Anything that is discussed between the client or potential client for a consultation and an attorney will remain confidential and will not be shared with the other side or anybody else. Work product is documents or other items that are prepared for litigation or for a case that may have notes or findings that you do while preparing and researching a case. The attorney for Mr. Heppner argued that the information was confidential because it was legal advice, and that it would be considered work product because it was in preparation for the potential case in consultation with an attorney. The government argued that it was not confidential or work product because it was being entered into a public domain. Claude, ChatGPT, Grok, all of those say that it is public information and used to help train their bots. Furthermore, it was not something prepared by an attorney to then maintain that attorney-client privilege or work product. Ultimately, the court ruled against Mr. Heppner, saying that it was not work product because it wasn't prepared by an attorney, and even more so at the end of the message given with the legal prompts, Claude told him that this was not legal advice and that he should consult with an attorney. Additionally, it was not considered confidential because it wasn't interaction between an attorney and a client or a potential client. It was information the defendant was freely giving to Claude for his own individual research. Had he been saying that information to an attorney, then it would not be open to the government's use in the case against him. So, as a result, if you do any kind of legal research and you're charged with the crime or there is a reason to look into anything that you have typed into AI, that information is going to be open for attorneys to discover and use against you. A little caveat to this case that could have protected the defendant was if the attorney had advised the defendant to do some legal research to prepare information specifically about the defenses he could have or the claims that are against him, then that could have maintained the attorney-client privilege and confidentiality because it was under the direction of an attorney. However, because all of this was done alone on a public domain and prior to consulting with an attorney, it was deemed to not be confidential and not work product. Therefore, the government can now use the very specific wording and details he put into Claude in the case against him. And you can imagine it's pretty damning. The court doesn't go into detail about what was typed and what was provided to Claude, but you can imagine a defendant facing $150 million wire fraud charges, among other things, was going to type in some very specific things to determine what defenses he may have. Those specific things that he typed into the AI can now be used by the government in the case against him. That's not great. So a summary for you is to always consult with an attorney. When you consult with an attorney, even if you don't hire that person, the information you share with that attorney is confidential and will not be shared. And now we have learned through this case that if the attorney directs you to do certain things using AI, that it may maintain that confidentiality. Now I say may because this is going to be something that will develop over the years. And ultimately, when you are typing into a ChatGPT or Claude, it's open. It's going to train the bots, and so therefore it's public information. So be careful about what you type into AI, because you never know how it may come back to bite you. And as you can tell with this Mr. Heppner, it has not gone well for him, and I'm sure he'll be seeking a plea deal very soon.